Good afternoon, Judge Glacier. I know we're a few minutes early, but I just wanted to let you know that we have representatives from both sides, as well as the court reporter, ready when you are.
Great. I will I'm ready now, so you can bring them all in. Good afternoon, everyone.
Good afternoon, Judge.
Mr. Johnson, I can see you dressed up for me. I actually wore something nice today as opposed to the t-shirt that I'm usually wearing, thinking that, oh, you know, other people are going to actually see me, but
I'll apologize to court and counsel. I'm on my vacation with the family. So if you hear kids running, dogs barking, but I did not exactly do the court appropriate matter, so I apologize.
don't worry. You know, if anybody is fine with it, you know, it would be me. So welcome to you. Welcome to Mr. Donnelly. Welcome to Ms. Roberts, our court reporter. Let me call the case. And Ms. Roberts, I don't know if you were the reporter on my last case, but I wasn't very conscious and good about keeping the record clean, and I promised to do better this time.
I've been with you once before, Judge Glacier. It must not have been that time, because when I was with you, it was okay.
Okay, thanks. Well, I'm always trying to improve. So let me formally call this Court of Claims matter, which is case number, give me a second here. I've got 21076 MZ, and it's Mark Goss and Christy Goss versus estate of Roy Lee Pederson. And counsel, could you identify yourselves for the record?
Afternoon, Judge. Ben Johnson and Paul Doherty on behalf of plaintiffs.
Good afternoon, Your Honor. Mark Donnelly on behalf of defendant.
Great. Thank you both for coming. Let me tell you why I brought you here on what really is a pretty straightforward request on the part of the state or the defendant for a stay. I'm going to summarize where my thinking is. And primarily, Mr. Donnelly, I want you to help me understand why you think a stay is appropriate, because I'm struggling with your argument, and I wanted to give you this opportunity to persuade me, or to at least explain to me the pluses and the minuses. So here's my perception. And when I finish, Mr. Donnelly, I'm going to ask you to tell me where I've gone astray, or how I'm on the wrong track, or where my thinking is incorrect. So the case that's before us today involves a collision between a four-wheel utility vehicle driven by Mr. Is it Pederson or Pederson? Does it matter?
Pederson.
Okay, by Ranger Pederson, an employee of the Department of Natural Resources, and a snowmobile driven by Mr. Goss. In this case, Mr. Goss's complaint seeks to get around governmental immunity by invoking gross negligence. There is another case, and that one was filed in 2019. Same facts exactly, but the legal theory for getting around governmental immunity is different. In that case, the plaintiff has tried to use the motor vehicle exception to avoid governmental immunity. And I read the Court of Appeals opinion, and I read Judge Kelly's opinion. So the issue in that case centers on whether or not the vehicle that Mr. Pederson was driving qualifies as a motor vehicle under the statute. So it seems to me that what we have here are two cases that arise under exact the same, if you want to say operative nexus of facts or nexus of operative
Yes.
facts, whatever they taught us in civil
Yes.
procedure.
The judge
Yes.
went out. Did anybody ever hear that drag on when the judge went out?
Yes,
Oh, I
ma'am.
did go out?
I don't think anybody heard what you said there, but
Okay.
I've gotten every word up to hear it. So it seems to me that what we have here are two cases that arise, and then your voice kind of dragged in. You couldn't understand.
Okay. Let me go back. I'm at my office today, and frankly, the internet at my office is not nearly as good as Comcast at my house. But anyway, which just shows that private industry sometimes can do it better, right? Okay, so I said that both cases arise from the same nexus of operative facts. In both cases, the legal object of the plaintiff is to get around governmental immunity, but the factual basis for both claims is identical. Now, it also seems to me that and I know that the motor vehicle case, the motor vehicle exception case is now in the Michigan Supreme Court. And leave was granted. I don't remember if it was leave or a MOA, but in any case, the case will probably be heard. I believe the briefs are due in October, so we're probably looking at a January or February sitting of the court. And potentially a decision not until June or who knows when. But anyway, the point, I guess, is that aside from the legal issues, all of the other issues are the same. The factual bases are the same, and that it doesn't matter in a sense to this case what the Supreme Court does. In other words, if the Supreme Court were to decide that it's not a motor vehicle under the motor vehicle exception and reverse the Court of Appeals, this case would still go forward. So I'm left with the thought that staying this case makes very little sense, especially if the two of you could possibly agree that for discovery purposes, this case should be consolidated with the other case if the other case survives the Supreme Court. So, Mr. Donnelly, tell me where I've messed up.
That's a very dangerous place for me to have to start, Your Honor. I think from a synopsis of where we are procedurally, you're correct, and you're also correct. It's very straightforward. Here's why we think a stay is appropriate. Had this case been filed as one originally, or even separately, which often happens in motor vehicle cases where, and this has gone back, since way before the Court of Claims Act was amended in 2015. It wasn't unusual for a plaintiff to file an action in circuit court and an action in the Court of Claims, one alleging gross negligence on the part of the driver, and one alleging negligent operation of a motor vehicle, that exception to governmental immunity. And when that happened, the cases would be joined together, and they would proceed as one case. So had plaintiffs done that in this case, and we filed the same motion for summary disposition as to the state, because we don't believe the vehicle that Ranger Pederson was operating was a motor vehicle, and this same scenario happened, it was denied, we took an appeal, this entire case would be stayed. It's not just stayed as to the state, it would be stayed as to the claim against the estate as well. So part of our argument is that this is an end run around immunity and the automatic stay that's provided under MCR 2.614D. Number two, I've been told tacitly, if not directly, that this action was brought solely as a placeholder, because the plaintiffs were concerned that if, in fact, the Supreme Court reversed the Court of Appeals and the Court of Claims, that the statute of limitations would run out against any opportunity to file against the estate of Mr. Pederson. We don't believe this is a gross, and so they've done that, and I understand that. I don't think in any way, shape, or form this is a gross negligence case. We could go through discovery, and we would file, if the court denied it, we would file another motion. We would file another notice of appeal. But what's particularly troubling is that
wait, so let me stop you. You would file a notice of appeal on a stay order?
No.
I mean, we haven't even got, I have to tell you, I know nothing about the merits of this case other than what I read in the Court of Appeals opinion. That's the sum total of what I know.
No, I apologize if I misspoke. No, we would not on a stay order. No. If this proceeded through discovery and we came to motion practice on the claim against the estate for gross negligence.
Okay.
And it was, okay. And significant in this case, another major reason, this is, as you might imagine, very distressful to the widow, Mrs. Pederson, that now she is brought in, and although she won't have a big role, I'm obligated ethically to let her know everything that happens as we proceed through discovery, should we do that. And so, my feeling, since it was a placeholder, there isn't gross neg, that we should just wait. The real case here is the case against the state. The plaintiffs will either rise or fall on that, and not on the case against the estate of Pederson. There's also no prejudice to Mr. Goss, and I do understand that he's been injured. He has suffered significant injuries, but his health, his medical bills are being paid for through his primary care insurance. So, there's also an issue you should be aware, Your Honor, that while we have agreed to represent the estate of Mr. Pederson, it's unsettled whether the state would indemnify Mr. Pederson's estate that did not exist until the plaintiffs created it. So I think for all these reasons that we just let this, we let it play out. I will acknowledge to the court, yes, the discovery that's done in this case could be used in the other case. I would think that would be appropriate. I don't know any reason why we would not agree to do that. It would be unnecessarily duplicative not to. So those are really the main reasons. The distress to Mrs. Pederson, because I believe if from talking with not with Mr. Johnson, but with other counsel, that if the Supreme Court denies the appeal, I would hope that they would dismiss the case against the estate. And because then the burden, if it's a motor vehicle, the burden simply is negligent operation versus gross negligence.
Okay, that's helpful. Mr. Johnson?
In a twist of fate, I don't even know where to begin with what you've just been told.
Well, you don't have to address the widow's concerns, because that's
Actually, Judge, I'd be happy to.
okay.
For once in my life, for once in 35 years of practice, instead of filing the case jointly, like I always do, because Ms. Pederson, the widow, and because her husband was absolutely
Yep.
My-
Mr. Johnson, you're breaking up. Hold on, because,
Because, can the court hear me now?
yeah, now we can.
Because of Mr. Pederson literally burning to death while my client was burning but lived. For once, I exercised what I thought was good judgment for a change and said, let's not sue her. Let's proceed. Because I absolutely would never have predicted that my client's own, that this is not a government-owned vehicle.
Mr. Johnson, you went out, so my transcript is not gonna make sense right here in this section. I got every word, everybody said, and you said, let me tell you where I left off. Let's proceed, because I absolutely would never have predicted that my client's own, and then you went out.
Thank you. His own state, to whom he and his wife pay taxes, would take a position that this was not a government-owned vehicle. The state, shortly after this complaint was filed, Judge, filed their MSD. It was denied, went to Court of Appeals, unanimously affirmed the denial, and now, of course, going to the Supreme Court. My client has had zero discovery, zero redress, despite the passage of multiple years. This is not, I don't know what a placeholder even means, very candidly, but we are in the position we are in because the state has decided to play the litigation strategy game that it has. This should go forward. Obviously, any facts we get in this case and any evidence we get will be admissible in both. They're all now both before your only, of course, the government vehicle part of the case is.
Mr. Johnson, I didn't hear that either. That kind of went out. We, and any evidence we get will be admissible in both. They're
In
now
both?
before.
Sorry, ma'am, both cases. So there's not going to be any problem in terms of admissibility there. But I would also indicate to the court that even after we had to file, our 3-year statute of limitations was up, Judge, in, I think it was late January of 2021. So I waited as long as I could. And then unfortunately had to make the decision to move forward to make sure that my client did have a day in court. We filed the case and for a way not to have Ms. Pederson be the PR, offered to have a probate lawyer be the PR so that Ms. Pederson did not have to take direct part in this litigation. I understand she preferred not to. And when counsel asked me to let her do what she wanted to do, I said, of course, I would abide by her wishes. So I just want the court to know, this is a horrible, horrible situation for everybody. But my client, severely injured to say the least, millions of dollars in medical bills incurred, having his hands virtually burned right off, Judge. It's time that we keep this case rolling and get discovery going, so that my client, who has a right to proceed, has to stay in court, and the state can do whatever they want to do and file every motion they want to file and do whatever they want to do. But I am not a believer that simply the Supreme Court denied that they're going to do the right thing, because they haven't done the right thing so far.
Johnson, I'm sorry. I'm sorry to keep interrupting you, but I don't know, your internet keeps going in and out, and I'm trying to make a good transcript. So you said, I'm just gonna go back and read a partial sentence. You know what you were, and file every motion they want to file and do whatever they want to do. But I am not a believer
that the state is going to do anything other than what's right for the state under this situation. So I'm asking the court to deny the motion and let us go forward on discovery. Thank you.
Mr. Donnelly, let's assume hypothetically that the state that you lose the case in the Supreme Court. In that circumstance, how are you prejudiced by this case going forward?
The state is not, the estate is. Ms. Pederson is.
Okay, but that's the same prejudice that would arise from any lawsuit against any estate. I mean, and when I started to tell Mr. Johnson that I didn't really want to hear about the woes of the widow, I mean, I don't mean that as that I'm cold or lack compassion for her, but just as a legal matter, I don't know that I can distinguish this suit against an estate from any suit against an estate. I mean, they all involve somebody died, and usually tragically. But I feel as though that whole drama, for lack of a better word, is not appropriately something the court can use as a decision-making factor. I don't know if that makes any sense, or if I'm just too hard-hearted here. But they brought a case. It's a legitimate lawsuit. You haven't brought a motion to dismiss it. I'm just looking at it like I would any other case and trying to figure out what the prejudice would be to you if discovery goes forward.
No, well, again, and I don't want to unnecessarily rehash things. It had it been brought at the same time, and we brought the motion, everything would have been stayed. Mr. Johnson's acknowledged that he never wanted to bring the case, and that he brought it just because it was on the eve of the statute of limitations. That's a placeholder, because the real case is against the state of Michigan, not against the estate of Mr. Pederson. And yeah, we will bring a motion at the end, because even under this scenario pled by plaintiffs, and as we anticipate witnesses will testify, it just doesn't add up to gross negligence. And we'll bring that motion.
Okay. I mean, I hear your point. I just want you to know that I hear your point about the fact that everything would have been stayed had the cases been brought together. You're absolutely right about that. But I also think that this wasn't, it strikes me that this wasn't a malign attempt to get around the law or the court rules. In other words, I think that it appears to me that what was done here procedurally was within the bounds of propriety. Now, that doesn't mean my mind is closed on that issue. I mean, obviously, if I'm missing something, you'll bring it to my attention, I'm sure. In other words, I don't think this was a devious attempt. Nothing, and I don't think you do either, that this was a devious attempt somehow to structure this case to avoid a stay.
I'm not suggesting that.
Right. I mean, I think the cards played out in a way that the plaintiff probably couldn't have predicted. I'm not sure you could have predicted. Frankly, when I read the Court of Appeals opinion, I know they're my colleagues, but I can't understand why the Supreme Court granted leave in this case. I guess they'll enlighten us someday. And I haven't read any of your pleadings in the Supreme Court, and maybe that will help me too, if we get to that point. But okay. Well, let me ask you this. Assuming that I do decide that there will not be a stay, what is your position on consolidating this case with the other case, at least for the purposes of discovery, so that should the other case survive, there would be an automatic transfer or automatic sharing of the discovery materials by order of the court?
The case should be consolidated for both discovery and trial.
Okay.
I mean, there's no question about it. And had this case been brought earlier, and again, I'm not suggesting that Mr. Johnson or any of his colleagues, filed it. They filed it because, I mean, he said why they filed it. you know, as a safety in the event that the Supreme Court reversed the Court of Appeals. That's, I mean, that's the writing on the wall. But this case should be consolidated with the original case, and it for all purposes, not just discovery. Which is why, you know, gets back to the, you know, the fact that the stay should be there, because part of the case is on appeal.
Mr. Johnson, what is your position regarding consolidation?
Absolutely should be stayed for purposes of discovery. At this point, I am concerned that if we say that it is being consolidated for all purposes, the state may try to make it therefore part of the appeal somehow. So I rather that we not bridge right now. If this case goes to trial tomorrow, Judge, then obviously it should be tried as one, like we would, or depending on the circumstance, the appellate situation with the vehicle exception. In some cases, I've dismissed the gross negligence case against the individuals in, for example, police misconduct cases where the officer didn't have lights and sirens on, going through a light, etc. But we're not there yet. So I have a real concern about saying for trial right now. I don't think we need to do that. Absolutely agree.
You said I absolutely what?
It be done for purposes of discovery.
Okay, does anybody want to say anything else? I'll prepare. I'm going to think about it a little bit more and I'll work on an order, but I want to give you guys the chance to say anything else you want to say, Mr. Donnelly.
I guess my final thought would be on this is that we don't want to try this case twice. You know, and I appreciate Mr. Johnson's comment that, you know, he's not ready to agree that this should be consolidated for all purposes, but it would seem to me to be a tremendous both a waste of resources and frankly an injustice to try you know, to try perhaps the case against the estate, and if there's a no cause at the end of it, then to get a second bite at the apple and go against the state on a lesser threshold. That makes no sense to me.
I agree with you there. So I mean, I can't imagine, Mr. Johnson, how the state could use a consolidation order to somehow put the second case, the gross negligence case off the tracks, but I'll think about that too. I don't know if Mr. Johnson was about to say something. Were you about to say something? Because you've frozen.
Sorry, I said, thank you, Judge.
Okay, all right. Okay, well, thank you both. Thank you. This has been helpful for me. I appreciate your time today, and I'll get you in order in the next few days.
Thank you, Your Honor.
Thank you, Judge.
Okay.
Any need for transcription, Judge?
I don't. Thank you very much, Ms. Roberts. Gentlemen, do you need transcripts? Are you okay?
Not at this time, thank you.
Thank you.
Johnson, you're frozen.
Thank you.
Mr. Johnson, no transcript for you either?
No, thank you.
Oh, okay, I'm sorry. You were
I
kind
couldn't hear.
of for a minute.
I couldn't hear him either, so.
Okay.
Sorry.
Okay.
All right, thank
Bye,
you.
everybody.
Bye.
Bye.